Good evening, early evening, actually. It's 4:15 Central Standard Time. So yeah, I blew off Lauren tonight only for us to go live, but we're
It
going to
was
be
at my
doing
insistence.
it was Allie was very insistent that we do this tonight. I agree.
I
Once
mean,
I read it,
yeah, he fired back. And my granddaughter doesn't get here till 6, so we've got dinner already and cooking.
we
So
did some dual cooking. It's quite enjoyable. I thought we were going to go out to eat, or I thought we were going to my son's house. All that got scrapped, and so we ended up making a nice Italiano meal. A little of the bacon a little of my grandma's meatballs that Allie is a master. It's so good. It's so nice. All right, so like we did yesterday, we do like I have to start promoting this podcast. We looked at our numbers, and I've been slacking so much on the podcast. Like, you guys have to start listening to our podcast. Otherwise, we're quitting YouTube. It's that simple. It's like I can't like kill my podcast by having the YouTube, because the podcast is my first love, and there's just not enough people listening. So what we're going to start doing, and I'm warning you now, we are going to make podcast only episodes where we discuss things that we're not discussing on lives, to draw
Ooh.
all of you in, to draw you into the podcast. Everyone that is here every single day that loves us, if you haven't listened to Gacy, I don't understand. It doesn't matter if you don't want to hear about Gacy. It's not really about Gacy. It's about the victims, whatever.
And
Start
Bob's
listening to the
amazing
podcast.
storytelling.
It's really it's great. It's scripted. I'm super proud of it. It should have millions of downloads, and it doesn't, but it should. It's got a lot, but not. You're just on time, Sleuthy. So all right, tonight, as you guys are aware, Andy Baldwin fired back. He had a very saucy, snarky reply. I would categorize it as such. So we're gonna do that. We're gonna go through it. We're gonna buzz through it. Our hope is to get off here at 5:45. So we hope that we can get through it. It's a relatively quick read. Oh, hold on. I'm gonna set a goal for y'all, because we're going twice today. I think we've earned some supers, so I'm doing it. I don't care what Allie says.
Don't set
Says
such a
it's
low one.
tacky. I'm gonna set a goal for 1,000 supers.
Okay.
Okay. No, I'll set a very reasonable one.
No, set an unreasonable one.
Oh, super crazy. All right, I'll set 30 chats. 30 chat. Let's see, 30 supers, and I'll sing you happy birthday during the live at the end.
You better sing it the way I like it, though.
I will.
Okay.
Only if we make it, though. If we don't make it, then y'all have to start guilting each other into making it so that it happens.
All right, enough, grifter.
Grifting. Everybody loves grifting. All right. Okay. All right. So what we're going to do is like we did yesterday. So I'm going to now do the official kind of intro.
I want to thank everybody for all my birthday wishes first.
Okay.
Thank you, everybody.
That was easy. That was super easy. All right. So let's, you ready? You ready to go, babe? Ready to do it?
I'm ready.
Okay. Welcome to the docket. I'm your host. Oh, scratch that. Forget that. Welcome to the docket, presented by Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the people of the state of Indiana versus Richard M. Allen. And I am joined once again by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So we've got a reply, babe. And
From who for what?
we have a reply from Andrew Baldwin, one of Richard Allen's attorneys, to the response that we just went through very recently from Nick McCleland in relation to the only pending motion that exists in this case in the lower court, which is the motion to preserve and produce specific evidence and a request for a hearing. So we went through Nick's. I wasn't impressed. We're going to go through Andy's. It's a thing. It's a thing.
He's firing back. He's firing back.
He is certainly firing back. I would call it a micro Frank's memo. That's how it reads. It reads like a micro Frank's memo. So I text Andy. I'm like, hey man, I read your reply. And saucy. I was like, I told him, I said, I can envision you behind your antiquated computer, just pounding like in that office with all his album covers on the wall, all by himself, like talking to himself. Yeah. What do you think about this, Andy? Well, what about that, Andy? And I could just totally see him doing.
Wait, he's talking to himself. He's calling himself
Yeah,
Andy.
like I do that all the time, but I'm weird. So.
You say, what about this, Bob?
Well, oh yeah. What about this, Nick? Sorry.
There you go. That's what I thought you
me.
meant. I wasn't quite sure.
Thank you for correcting me on that because it was a horrific blunder. All right. So without further ado, let's pull this guy up and start blasting through it. We'll alternate pages because it's fun. It's fun to alternate.
Or if is there subsections, we can alternate sections.
We can. All right. So I'll do the first section and then you could do the next one. So because there's definitely subsections. All right, let me get this on scrolling. Okay. All right. So we have Richard Allen's verified reply memorandum to State of Indiana's response to preserve and produce and request for sanctions. It's asking for sanctions, babe. What do you have to say about that?
Let's see. Let's hear it.
Oh, wait, hold on. Okay, comes now Richard Allen by counsel and files this reply to the State of Indiana's February 28th, 2025 response to Allen's motion to preserve and produce, and also request sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. The prosecution's response brief provided proof that the state of Indiana failed to turn exculpatory evidence over to the defense. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though in a February 13th, 2025 email, he denied possessing such letters. McCleland also has no explanation as to why a letter from Davis from October 15th, 2024 is missing and cannot be found. Instead, the prosecution spends the majority of his response denigrating defense counsel, namely Andrew Baldwin. Prosecutor McCleland is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. Hear, hear. The law is the arbiter. Quote, exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence, end quote. State v. Durrett. And that is a 2010 case. Carroll County Local Rule 18B2 also requires McCleland to turn over exculpatory evidence. Based on his February 28th, 2025 filing, we now know that the state of Indiana had certain letters in its possession in October of 2024, but failed to turn those letters over to the defense until February 28th, 2025. The prosecution only produced those letters after, underlined for emphasis, the defense sought those letters being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. This behavior of the state is consistent with a pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of the case, as will be recounted later in this memorandum. A pattern of withholding exculpatory evidence may lead to a reversal and new trial. Pruitt or Prewitt v. State, that's a 2004 Indiana case. Quote, this case illustrates what happens when the state engages in a pattern of withholding exculpatory and material evidence from a defendant prior to trial. In Pruitt, the Court of Appeals reversed the conviction when, soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. Defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13th, 2017, the victims were abducted, taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14th, 2017, in parentheticals, after the search parties had left the area, they were ultimately transported to the location where they were found on February 14th of 2017. Further, the defense's theory was that evidence strongly supported that multiple people were involved in the abduction and the unalivings of the victims. The defense theories were detailed in the defense's opening statement and throughout the trial or in offers of proof from August 1st, 2024.
I just want to chime in before you get to the state's theory. I actually tried to earlier, didn't realize I was on mute. But he's getting into each side's theory because the defense is about to lay out why they believe this evidence is exculpatory, despite McCleland's position on the evidence, on what the scene says to him and means, all of those things. So this is why he's going to get into both the state's theory and the defense's theory.
The state's theory was that in some order, the following events occurred. The killer, acting alone, after running or briskly walking across a bridge to catch up to the girls, in parentheticals, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video, walking casually, in parentheticals, and not panting like a 45-year-old man who had run across the bridge. Then abducted the two victims, slid down a steep hill with those victims. Then, in a panic, after observing a van, corralled those victims across an active creek while holding a gun, and then both victims somehow were undressed. But the younger victim was later redressed in the pants, bra, and sweatshirt of the older victim, and the lone panic killer unalived one victim and then unalived the other victim without anyone hearing any screams, in spite of sound traveling very well throughout that area, all the way to the bridge. Then the lone panic killer moved the older victim from one area to another area next to a tree without any drag marks, indicating that he carried her from one place to another. All of that activity, according to the state's theory, occurred in a 19-minute time frame between 2:13 p.m. and 2:32 p.m. Attack the timeline. When the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the unalivings, the state's theory was that this panicked killer then took time to place sticks on top of the victims' bodies, in parentheticals, in particular patterns as depicted in photos admitted at trial, and then, in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery before this panic killer chose to walk westbound towards his vehicle on 300 North in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road after having killed the victims an hour and a half earlier. The state's theory was not that multiple men or women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13th, 2017. Your turn.
Reese. Sorry, guys.
Are you pulling it up on your own?
Yeah.
Okay. I'll follow.
Reese Davis. So this next section is entitled Reese Davis letters provide exculpatory information that support the defense theory and negates the state's theory, and also provides other information that the defense could have utilized for trial to support its request for third-party suspect evidence to be admitted into evidence. The Davis's letters that the state of Indiana did not turn over to the defense before or during trial. Reese Davis stated that Kagan Klein, a suspect in the case, confessed to the murders. A key suspect confessing to murders is exculpatory evidence, bolded, as it tends to establish a criminal defendant's innocence. Citing back to State v. Durrett. No, sorry, Pruitt. At a minimum, Carroll County local rule required McCleland to immediately turn those letters over to the defense, even if he, McCleland, believed that the letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Klein and Logan. Footnote 1 reads, Carroll County Local Rule 18B2. Additionally, McCleland's claim that he was not obligated to turn over the letters because of Davis's claim that Richard Allen was involved is not a judgment call for McCleland to make. And I'll repeat that because I stumbled over it. McCleland's claim that he was not obligated to turn over the letters because of Davis's claim that Richard Allen was involved is not a judgment call for McCleland to make. Richard Allen was home on the evening of February 13th, 2017, and the morning of February 14th, 2017. According to Davis's letters, Klein indicated that Allen was with them that night and morning, assisting in the unalivings. It is McCleland's obligation to turn over exculpatory evidence to the defense and let the defense determine how to proceed. Returning now to the body. When police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. So, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather in its absence, he received a fair trial understood as a verdict worthy of confidence, citing Supreme Court case Kyles v. Whitney. The jury in Richard Allen's case was out for nearly 4 days, a very lengthy deliberation. In this case, Kagan Klein's confession to the murders and also Klein's claim that Ron Logan was involved are clearly exculpatory statements. These were the two most likely suspects during the investigation. If it could not be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of third-party suspect. If it could be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of the third-party suspect defense and also for a jury to consider. The fact that Klein also implicated Allen would not have been of a concern of the defense, as the defense knows that Allen has no linkage to either Klein or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and the morning of February 14th, when Klein is claiming Allen was with Logan and Klein committing the crimes. Had the defense known the information contained in the Reese letters, it would have renewed its motion for third-party suspect defense regarding Klein and Logan, and it would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Klein. The defense could have argued that Kagan Klein knew details of the crime that no one else knew, and furthermore, that he, Klein, was protecting an unknown third party by claiming that Allen was the third party after Allen's arrest. The defense could do none of that, as well as any other number of legal or strategic or procedural maneuvering if it, the defense, was in the dark about the contents in the letters while the prosecution was fully aware of that information. The details that Klein provided to Davis add to the exculpatory value of those letters. On page 4, okay, this one I think is very important. On page 4 of one of the letters, Davis claims that Klein detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore, that the bodies were staged. These facts are consistent with the defense theory and facts that oppose the state's theory. Furthermore, in the letter, Davis claims that Kagan Klein detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time to purchase exotic fish after having asked a relative to assist him, Ron Logan, in creating an alibi. These are all facts that Reese Davis would not know, but that the killer would know. All of those facts tend to establish Richard Allen's innocence. In the second letter, Davis claims that back in 2018, so this is before any details whatsoever were released about the manner of death. In any event, that was me ad-libbing. But Davis claims that back in 2018, he, Davis, reported that the victims' throats were sliced. This is something that only the killer would know, especially when the details of the murder were not known at the time. He also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution theory. On page 3 of that letter, Reese recorded that Kagan Klein told him that the scene was staged, and furthermore mentioned that the girls could not move because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to a place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory. In his February 12, 2025 interview at Newcastle Prison, Reese Davis further provided details that he, Davis, claimed or believed that he also provided to the prosecution concerning details that Kagan Klein stated to Davis. In that interview, for example, Reese Davis claimed that Kagan Klein stated that the girls were handcuffed to each other. After the meeting, defense counsel Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there were any indicators on the victims' wrists that would support this new information that the victims were handcuffed to one another. The admittedly non-expert eyeballs of the attorneys and the investigator observed straight lines on the hand of the wrists on the left hand of the wrists of both girls, which, if true, could indicate that one victim walked immediately behind the other with each of their left hands handcuffed to each other so that they could not easily run away. If the defense had received these letters, it could have learned these facts from Davis during deposition, if they weren't contained in the letter, and then had experts view the same photos to determine whether the photos were indicative of the girls being handcuffed. And while we continue to read this, I'll ask someone to get us over. Do we have pictures that do not expose the body but show the wrists?
No.
Well, maybe we do. I'm going to think about this while we. All right, moving on. Had the defense known of the Kagan Klein statements to Reese Davis, it could have brought both Kagan Klein and Reese Davis in for deposition after hours or during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Kagan Klein finally admitted that Richard Allen had nothing to do with the crimes, as Reese Davis stated to counsel during a jail interview on February 12, 2025. And also to show that Kagan Klein's claim about the activities of the third person involved with him, Klein, and Logan was inconsistent with Richard Allen's whereabouts the night of February 13th and the morning of February 14th. The defense likely would have called upon Kathy Allen to show that Richard Allen was at home during that time frame and not with Logan and Kagan Klein. Additionally, the defense could have asked the Department of Corrections to provide video from the very pod where Reese Davis and Kagan Klein were housed to determine whether Klein and Davis were frequently talking with one another, as Klein has apparently stated in State's Exhibit 4 that Klein has only talked to Davis, quote, maybe 2 times. If the video shows that Davis and Klein talked to each other well beyond 2 times, then it could be determined that Klein was lying. Whereas if the video shows that Davis only talked to Klein 2 times, then it would show that Davis was lying. Either way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McCleland's claim that he did not turn over the Davis letters because he, McCleland, made his own determination that the letters were not in fact exculpatory, denied Richard Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and to determine what to do, if anything, concerning the contents of those letters. In his February 28, 2025 response, McCleland makes much noise about Attorney Baldwin attempting to put into the public domain information through filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McCleland via email before filing his motion. On February 12, 2025, Baldwin emailed McCleland asking for the Reese Davis letters. On February 13th at 2:41 p.m., McCleland responded as follows. The information that we have concerning Reese Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out in regards to those motions. Before filing any motions, Attorney Baldwin made one more attempt to obtain the letters. The defense responded at 3:54 p.m. on February 13, 2025, by asking McCleland whether he was admitting or denying that he, McCleland, had received letters from Reese Davis in the months leading up to the 2024 trial. McCleland could have quickly answered the question and then provided the letters to the defense and perhaps avoided any more filings. McCleland also could have asked Baldwin to hold off on filing anything while he, McCleland, gathered the letters to turn over to the defense. Instead, McCleland chose to ignore the defendant's request, prompting the defense to file its February 14, 2025 motion to preserve and produce the Reese Davis letter. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Also, note that in his February 13th email response, McCleland claimed to have provided the defense all of Reese Davis' letters during discovery. This was simply an untrue and misleading statement typed on his computer and sent to the defense by McCleland. Through his February 28, 2025 filing, the court learned that McCleland actually was in possession of those letters on February 13, 2025, which contradicted McCleland's representation to the defense that everything had been turned over. McCleland chose to intentionally mislead defense counsel about his, McCleland's, possession of those letters. McCleland was getting called out by the defense once again, and footnote 2, quote, once again is referring to the other times that McCleland was forced to turn over items after being called out by the defense, as detailed in the next section of this memo.
Oh, shit.
No, I'm resuming the sentence. And once again,
my thing where I drop off though.
Oh, and once again, McCleland was ultimately forced to turn over the letters, perhaps out of fear that the defense would eventually gather Department of Correction records that would then expose McCleland's misrepresentation. Footnote 3. Allen and the defense are not conceding that the DOC records that McCleland admitted as exhibits are proof positive that other letters don't exist. The defense has no idea how records are kept and how accurate those records might be. The defense also is not sure how McCleland was so quickly able to access those records from Newcastle. Certainly, as detailed above, McCleland's response to the motion to correct errors, in which McCleland provides details found nowhere in the Reese Davis letters, provides a compelling argument for the belief that either one other letters exist or video exists that has not been turned over. And just to touch on that, that's to say that in the state's response, they included details that supposedly were told by Ron Logan that are not in what was provided to the defense in discovery. So where's he getting this other additional information? And that's what the memo is referring to right there.
Yeah, I mean, that's a real mystery. Like where he came up with this information.
Yeah.
Like the battery thing was really
Still not in that letter.
it's not in neither of those letters.
Not in the discovery.
Is it in the missing third letter? Is it in the interview that they don't have or have never had? Who knows? I mean, when you look at this from Klein's perspective, if the conversations took place after Richard Allen was arrested, which we know that they did because he wouldn't know who Allen was from a hole in the ground, they're completely self-serving. I mean, we know that Klein, at least according to Reese Davis, claims that, hey, man, I'm thrilled they got Allen because that takes me off the hot seat. They're not going to look at me anymore. So, I mean, anything
as long as Allen doesn't start snitching, or that's what he
right. So, but anything that he's saying is 100% self-serving in terms of trying to protect himself. I mean, like, why would he say anything, he being Klein, that would exculpate Richard Allen? That doesn't help him.
Why would he say anything that implicates him in the first place?
Wait, why would Klein say anything that implicates himself or
Yeah,
Richard
why is
Allen?
he admitting to having been involved in the murder in the first place?
I have no idea. He's bizarre. I don't know.
There was something else that I wanted to mention. I just want to note, because there was this reference in this section, that the defense didn't want to wait to file their motion because the judge might rule on the motion to correct errors beforehand, which might arguably kick the case to the appellate lawyers. The judge has since already denied the motion to correct errors. I can't tell whether or not, and maybe we have to go back and to look at his original motion, if in the wherefore clause, maybe you can do that while I'm finishing this section, or I'll do it while you're reading yours. But in the wherefore clause, if he sought leave, and I assume that he did, to supplement or amend the motion to correct errors once the letters were produced. So, but then
Osbrook will know.
Then she circumvented all that by just ruling on it anyway. But turning back to the body of the
I'm pretty sure that Michael has said that there is no supplementing, there's no amending. Motion.
I'm going to look at the wherefore clause.
Not 100% on, but I'm
going to look at the wherefore clause, and I'll let everybody know before when
Michael's in chat. And
I know, but we're doing a podcast now. You're talking about the chat.
Oh, okay. It's all right, dude.
Okay. Okay. Returning to the body of the document, McCleland's misrepresentation has yet to be explained by McCleland to this court or anyone else. Are the letters McCleland finally provided to the defense truly the only letters and or videos in his possession? McCleland's recent response to the defense motion to correct errors provided troubling statements that cast doubt on McCleland's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecutor's response to the defense motion to correct errors, in an apparent attempt to discredit Reese Davis, McCleland claims that he, McCleland, had information that Reese Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious because the prosecution has failed to produce any document or videotape in which Reese Davis made such a claim. The defense has found nothing. This leads to serious questions of where did McCleland learn this information? The defense is left with one of two possibilities. One, McCleland is a liar. No, that was me. One, McCleland has additional Reese Davis letters, reports, or videos from where he, McCleland, gained that information. Or two, for reasons that are unknown, McCleland made up the story. It seems unlikely that such a specific story would be made up, leaving the defense to conclude that McCleland has additional Reese Davis letters, reports, or videos, but has not turned it over to the defense. McCleland has not explained to this court nor anyone else from where McCleland claims he learned this information about the batteries, nor did McCleland back up his story about the batteries with an exhibit attached to the filing. And I will just note here, this is something that Judge Gull should call the prosecution on. I'd like to know, Mr. McCleland, how and where did you get this information? And tell me precisely when you produced it to the defense. I don't understand why these types of things get lost on the judge. And she never turns to the prosecution and says, why, where, how.
That's like every courtroom in the country. Like like defense attorneys just take beatings and like prosecutors just never get put to the fire. Like he needs to answer for this shit. She should want to know. In the pursuit of the truth, she should want to know. She should say, you know what? I'm curious. I'd like to know that answer myself. You've piqued my curiosity, Mr. Baldwin. I'd like you to answer that, Mr. McCleland. How did you know that information? Where did you get that information from? Did you make that up whole cloth? It's a strange thing to make up whole cloth. So if you didn't make it up whole cloth, where did it come from? Oh, it came from there. Well, why didn't you turn that over to the defense? I mean, it's frustrating. It's frustrating, and it's like it's one of the main reasons that like defense trial work just like really started to wear on me. It's like because in court, like on YouTube or on the podcast, I can scream and yell, and I have no repercussions. In a court of law, you have to sit there as a defense attorney and shut your mouth. Like, despite the fact that you're sitting there feeling like we're feeling, like, where is the finger pointing at the prosecution? Where's the finger pointing at the government ever?
Where is the true search for justice and truth?
It's crazy.
So returning to the body, nor did McCleland back up his story with the batteries with an exhibit attached to the filing. That's very suspicious. Also, note that in an email that McCleland requested Attorney Baldwin to file something, which Baldwin did, only to have McCleland then cast aspersions about the filing.
McCleland's history of holding on to exculpatory evidence until being forced or called out by the defense. Unfortunately, as has been the historical pattern of the prosecution, McCleland made the decision to hold on to those letters until called out by the defense, much like he made the decision to hold on to other exculpatory evidence over the course of the case. Again, Indiana Court of Appeals have commented on patterns of withholding exculpatory evidence and have even reversed convictions when the prosecutors have exhibited such patterns. Pre-wit. 1. Steve Mullen's claim that Brad Holder and Patrick Westfall and other crucial early interviews between 2/14 of 17 and 2/20/17 were, quote, recorded over, was not relayed to the defense until 1/30 of 24, in spite of the defense asking for that evidence since August 10th of 2023. As anyone in the criminal justice system knows, often the most important interviews are those interviews closest in time to the crime. Brad Holder and Patrick Westfall were on law enforcement's radar screen as suspects very early on in the case, a fact that is evident from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30th through August 1st, 2024 hearings. because of law enforcement's very early interest in Brad Holder and Patrick Westfall, each were quickly found and then quickly interviewed on February 17th of 2017, within 3 days of the homicides. On August 10th, 2023, the defense first unveiled to the prosecution that the defense, believed that the state's own evidence supported that Holder and Westfall were involved in the homicides. From a single 2-page document found among hundreds of thousands of documents, the defense found evidence that law enforcement had interviewed Holder and Westfall on February 17th of 2017, and that both interviews were memorialized through audio/videotape. It was after the August 10th, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. When McCleland and Mullen failed to turn over those interviews or explain what happened to those interviews, the defense called out the prosecution in the Franks memo filed on September 18th of 2023. Footnote 66 on page 56 of the memorandum details that the prosecution had failed to turn over the Holder and Westfall interviews that the defense had been seeking. Even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over the Holder and Westfall interviews, the prosecution still refused to answer the very simple questions posed by the defense of, where is the Holder and Westfall videos? Please turn them over. The defense heard crickets. Instead of immediately alerting the defense on August 10th of 2023 that those videotapes had been turned over, or that those videos had been taped over, McCleland and Mullen said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents on certain hard drives that it had turned over to the defense. In the fine print on page 5 of this document, the defense finally learned what McCleland and Mullen were claiming happened to those crucial interviews. They, quote, were recorded over, end quote, along with all other crucial interviews between 2/14 of 17 and 2/20 of 17. Neither McCleland nor Mullen called the defense and said, hey, quote, we should have told you this when we first got on the case, or at least back in August of 2023. But those interviews you've been seeking for the last 5 months were taped over in 2017, end quote. Defense counsel, now that's what Andy is saying that they should have done back as early as of August of 2023. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullen and McCleland's claim that the crucial video was taped over, as such information was sandwiched between other minutia contained in the document. This should also not be overlooked. If, in fact, those crucial videotaped interviews were actually taped over, that would be colossal news that Mullen and McCleland would not have forgotten. Losing such evidence would be the talk of the unified command due to the serious nature and potential serious consequences of losing such important evidence. To lose such crucial evidence early on in a case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullen, nor the minds of those in unified command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullen and McCleland should have immediately said to themselves, quote, oh no, those interviews were erased back in 2017. I need to immediately tell the defense. I should have told them when we got the case, but I'll do it now, end quote. It's inexplicable that Mullen and McCleland would not have remembered in August of 23 when the defense first requested those interviews, that those interviews had purportedly been, quote, recorded over, end quote. Yet neither McCleland nor Mullen told the defense of this earth-shattering type of news that Mullen had known for 6 years at that time. To make matters worse for Mullen and McCleland, when the defense finally learned of the so-called recorded over interviews, the defense asked if there was some documentation memorializing what exactly happened to those interviews, how it happened, that crucial evidence had been, quote, recorded over. Surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had yet been tendered to the defense. Some point in time later, the defense finally received such a report. It was drafted by Steve Mullen. Inexplicably, it was undated. Therefore, no one knows if the report was drafted in 2017 or sometime in 2024 or anywhere in between. That document was entered as an exhibit at the March 18th, 2024 motion to dismiss. This undated document is not normal, nor the normal way that law enforcement and prosecution operate. The question must be asked, therefore, why did Mullen and McCleland not immediately alert the defense that the Holder and Westfall and many other interviews were, quote, recorded over when the defense first asked McCleland and Mullen for those interviews in August of 2023? And why did Mullen and McCleland not turn over the undated document, purportedly explaining how the interviews were recorded over until after the defense requested that document? The defense has not seen anything other than an undated document in the words of McCleland and Mullen that support that these interviews were actually recorded over. This is not normal and is very troubling. Neither McCleland nor Mullen nor anyone else in Unified Command has ever explained this to the court, nor anyone else why they did not immediately alert the defense that crucial evidence sought by the defense had been purportedly recorded over. Neither McCleland nor Mullen or anyone else has ever explained this to the court, nor anyone else why it took 5 months before providing a document detailing the claim of Mullen of what happened to those interviews. Those are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were, quote, recorded over, end quote. This is not normal.
And there is nothing normal about that.
It's not.
It's again something that should cause the judge pause to ask the prosecution to explain itself.
She doesn't seem to care. Talk about
doesn't.
inexplicably.
Right.
Why a sitting judge would not inquire as to any of this, even if she thinks that they got the right guy, which is really not her purview as the fact finder or as the gatekeeper of the evidence here. She wasn't the fact finder. Whatever she may think, that has nothing to do with this. They need to answer for this. The state, once again, needs to answer for their either inaction or action. And Baldwin's very clear. Baldwin is in no way, shape, or form completely believing the story that this shit was recorded over at all. I mean, he's saying without saying, I think that they recorded it or deleted it or recorded over it purposefully.
Yes. He said, if that's even what happened.
All right. So you want to read this one?
Paragraph 2. For over 4 months, McCleland held on to exculpatory evidence that he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned, essentially, that McCleland may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields, and perhaps others, were involved in the murders. As this court knows from the Franks memo, including documentation provided to the court in that memo, on May 1st, 2023, McCleland received through the United States Postal Service a certified mailing from attorney Paul Barada that detailed why his client, Todd Click, was concerned that McCleland did not have all the information necessary before making an arrest. This certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to the defense from the likes of Elvis Fields, Ron Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you are a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense by phone and alert them that the prosecution had received this information that was clearly exculpatory. And I'll just note here, there are no ifs, ands, or buts. Not even McCleland can deny that that was exculpatory. Moving on. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that they, the defense, would soon be learning of that certified mailing. In the August 10th, 2023 deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report where the prosecution had to know that Click was a member of that investigation trio of law enforcement along with Kevin Murphy and Greg Ferenczi. McCleland had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, through his lawyer, had mailed a letter, much like Reese Davis, to the prosecutor with exculpatory evidence. McCleland's failure to immediately turn over this exculpatory evidence has never been explained to this court or anyone else. Why did it take McCleland over 4 months to turn over this evidence? Similarly, it took McCleland approximately 4 months to turn over the Reese Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case.
You want me to read 3? All right. So why, in a September 6, 2023 email to the defense, did McCleland claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact, law enforcement had known the identity of the Purdue professor since mid-August of 2023, if not before then? And why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming it may not be able to learn his identity, which is insane.
Which is another huge thing that the judge just never.
Nothing.
Well,
No, I mean, nothing. None of this that you're hearing. And if you are Karen Reed, folks, and you're coming over to the Delphi thing for the first time, it's mind blowing. It's worse than Karen Reed. It just is. And now Richard Allen sitting convicted, sentenced to 130 years. And this judge just sat there and ignored every single circumstance that was put in front of her that there was something wrong with this investigation.
and with
Ignored
the
it.
veracity of the prosecutor and discovery process and all of these things that keep
Never
coming
held
up.
hearings. Never held hearings. They finally got 1 3-day period of time where they had to cram in their hearings, and that was it. In a case that was pending for a year and a half, they were booted off. They had to fight their way back on. Like this concept that prosecutors who have a theory and nothing more based on the evidence they have are the ones who get to dictate whether or not something could be exculpatory or not is absurd. Do you think any prosecutor ever wants to, once they've been in arrest and they've decided to formally press charges, do you think there exists a prosecutor in the world that wants to turn over exculpatory evidence?
No, I mean, it would be like in the Karen Reed case, if they found some evidence that he had been in the house or I don't know, anything that supported the same theory the defense is proffering, that the prosecution said, well, that's not exculpatory because it's not consistent with a car hitting the victim.
Right. And I just want to be clear about something. What's going on here and in Massachusetts and Karen Reed's case is not new. This is not something that just started, people. I've been yelling about this for 3 years. I've been yelling about it since I started my podcast. This is what the reality of the criminal justice system is. This happens all the time. All the time. If I had more time, I saw your text. I would bring Michael Osbrick on. He'll tell you he does habeas work. He wins. And he finds stuff like this all the time. All the time. So for those of you that are thinking, wow, we're in big trouble. No, it's always been like this. This is now, we have an opportunity in terms of where we're at with the social media and the technology that we can have voices outside of the courtrooms to call bullshit when we see bullshit.
And to expose it to the masses.
And expose it to the masses. And it always heartens me to see that people out there are equally outraged, because you know what? You should be. You should care. You should care. Because prosecutors and podcasters that sit out there and poo-poo defense attorneys and try to shame you because you may think that another theory is what actually happened by saying, oh, you don't care about the victims, are full of shit. I'll tell you that right now. We have every right in the search for the truth to try to figure out what the hell happened.
And to put forth different theories. I mean, there's so many people out there like, wait a minute, you're saying Kevin Kline, what about Odin? What about your Odin theory? Is that gone? It doesn't have to be gone. It's reasonable doubt. There are multiple other possible scenarios, each equally plausible to the one the state put forward. All the state has, we say a narrative, we say a theory. It's a story. It's their story. That's it.
I just want everyone to do a little homework. I suggest everyone watch a couple of documentaries regarding some wrongful convictions in this country. And when you kind of look at the number of wrongful convictions where people have been exonerated, it's shockingly low, because I am here to tell you that the amount of innocent people in prison would shock you.
Right. You're saying it's a high number, but it's underrepresented.
It's way underrepresented.
Right.
One is too high of a number. Let's get that straight. One innocent person that's doing time for a crime they didn't commit is too many. However, in terms of the amount of people that are actually in there who cannot find that lawyer that will help them, that don't have the money to get a lawyer to help them, that are merely one letter in piles of thousands that are going to innocence projects, or attorneys that handle habeas work or post-conviction work that just simply don't have the time or the wherewithal to handle these cases. It's unbelievable.
Or the procedural cards are stacked against them, and the court won't hear it no matter how compelling it is.
All right, I think it was your go, right?
Nope, you just read 3 and you read the subtitle.
Okay. So, in yet another example of what appears to be an attempt to conceal exculpatory evidence, McCleland has yet to explain to this court or anyone else why he sent an email to the defense on September 6th, 2023, claiming that he and law enforcement did not know the identity of the Purdue professor. And more curiously, that they may never learn of the Purdue professor's identity. I live about 2.5 hours away from Purdue. There would be 2, maybe 3 professors in that department. I mean, when you're talking about a university, you're not talking about thousands of professors that handles certain material or subject matter that work in a particular department. You're talking about a few people. That concept, when she decided, she being Gull, decided not to inquire at all, is stunning. Still, this is all old news. Andy's doing exactly what Alan Jackson did in their motion to dismiss. He's now compiling everything again in one document and pushing it onto Gull's bench and saying, for the love of God, please
something.
Read this. Do something, please. Prove to me that I'm wrong about you. Prove to me that you care about the truth, please. The Franks memo was filed on September 18th, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor, Jeffrey Turco, who happens to live in Chicago. I wanted to go find him. I really did when this was all going down. Only 13 days earlier, it was thought that his identity may never be known. According to McCleland, but after the Franks memo, in parentheticals where the missing professor was discussed, he was found almost immediately. Let there be no doubt, the Purdue professor's report and even his October 19, 2023 interview revealed that the homiciders, the unalivers, may have left behind sticks in the form of runes consistent with the defense theory. This is called exculpatory evidence. Huge footnote. Footnote 4. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said, quote, the argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible, bolded. These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not be surprising if Holman or McCleland would want the defense to not have access to the report, as that report supported the defense theory that Norse paganists left the sticks behind in the form of runes. In his September 19, 2023 interview with Holman, Turco commented, quote, I think the idea that somebody is trying to kind of replicate, early Germanic, runic script, that seems, I think, a given.
A given. And not everyone has this independent knowledge. I think all of us as human beings who've walked this earth know that's not common knowledge. What a rune is, what it looks like, how to form one, how to either make a scene look like something it's not, or to use them in an actual, for your own purposes, that they mean something to you. Well, either one, you need to have the knowledge in order to do it.
100%. You're not just guessing. You're just not out of thin air putting some sticks that just happen to look like Germanic runes.
And Bob, remind us what the name of the tattoo parlor in town is called.
Odin's Den.
So Odinism is a thing, known in that area. This is not something that's not part of the culture there.
Odin's Den. Both the report and Turco's own words in his interview stray far from what Holman represented in his August 10th, 2023 deposition as to what the Purdue professor's words were. Holman claimed under oath that the Purdue professor had stated that the sticks were, quote, not Odinism or any type of cult worshiping or any type of group that would have conducted the crime, end quote. Holman, simply put, misrepresented under oath the findings of the Purdue professor, who never said that the sticks were not representative of Odinism. Rather, the words the Purdue professor used was that the possibility was, quote, quite plausible, and that it was, quote, a given. Holman's misrepresentation under oath is very troubling, and he has never explained himself to this court or anyone else. The defense believes that the evidence supports that McCleland did not want the defense to learn the name of the Purdue professor, and thus September 6, 2023 email that he, McCleland, has yet to explain.
Not unlike them saying Richard Allen made a statement that he parked at a certain spot. Richard Allen made a statement that he arrived at a certain time. Richard Allen made a statement that he took a certain route, none of which turned out to be accurate.
Back to the body of the memo. Turco's report and interview supported the defense theory that Odinist Norse paganists were the unalivers that left behind ruins was the crime scene.
And Bob and I'll add here because he didn't, or someone trying to make it look as though it was.
Exactly. After Holman's September 19th, 2023 interview of Turco, Holman prepared a report dated, because reports are normally dated, September 22nd, 2023, in which Holman admitted that he had known of the likely identity of the Purdue professor since mid-August of 2023. If this is the case, again, why did McCleland not disclose this information to the defense instead of claiming to the defense on September 6th of 2023 that the identity was unknown and may never be known? Again, McCleland has never answered that question to this court or anyone else. To the defense, it appears as yet another example of McCleland's attempts to conceal exculpatory evidence from the defense, much like the Reese Davis letters. And it is not normal.
4. Why did McCleland fail to turn over the fake crime scene photo found on Holder's Facebook page even to this day? And why did Trooper Roland Purdy twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook page before the unalivings, only to then change his story on August 1st, 2024 at the hearing on third-party suspect evidence? As has been noted in the Franks memo and at various other times, the defense found among the massive amounts of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted two girls mimicking the very crime scene that law enforcement found on February 14th, 2017. This image depicted two young girls lying on the forest floor with sticks and/or branches on them, with one of the younger girl's arms posed almost identically to that of the Liberty German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Ronald Purdy. Why would Brad Holder, an early suspect, have such an eerily similar image on his Facebook page? Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher, who had located the image on Brad Holder's social media pages. Trooper Purdy, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he, Purdy, did not find the image compelling because it had been on Holder's Facebook page for a few years. On July 30th, 2024, Purdy once again confirmed under oath that this eerily similar fake crime scene image was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his two previous sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page. What? I mean, I know we all know this, but I'm going to say it again. What? Well, what is the point of people swearing to things under oath, to going to depositions, to requiring affirmations on written documents and in pleadings and during depositions and testimony, if they can just change their story later without any repercussion? Moving on. Additionally, Trooper Winters claimed in his deposition that Indiana State Police, ISP, could not locate the faked crime scene image that at one time was in the possession of ISP post in the possession of the ISP post in Lafayette. To this day, The prosecution has failed to turn over said image. This is not normal. It is also not normal for a seasoned state trooper like Ronald Purdy to retract 2 prior sworn statements during a hearing in which the mimicked crime scene images was a central piece of the defense's argument to allow third-party suspect evidence at trial.
5. Video of Brad Holder and Westfall and pagan ritual in Fort Wayne. The defense was fortunate enough to locate among hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12th, 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. Footnote 5, which states, this video is discussed in the Frank's memo, page 67. In the video, Brad Holder was tape recording various people in his ceremony, periodically yelling out things such as, "Hail Thor!" At the very end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand to seemingly mark something on the tree. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree in one of the victim's blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution to turn over evidence of an exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over that evidence immediately without any need to request it. This was yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over.
Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until being forced to provide it to the defense by complaints from the defense is not normal. Prosecutors claiming that they can't locate a key exculpatory witness's identity, parentheticals, a witness, mind you, that purportedly altered the way the case was investigated, is not normal. Later, learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming that he had never learned of the witness's identity is not normal. The prosecution having no explanation for not providing exculpatory evidence to the defense is not normal. Having no explanation why a report that attempted to explain why key evidence is forever lost that was not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Finally, having a prosecutor claim in an email that he provided all the Reese Davis letters to the defense before trial, when just 14 days later he was forced to admit that what he, McCleland, represented as truth in his email was in fact not true, that is not normal. Nor is it normal that one of the letters can't even be located and that the prosecution has no explanation for the missing Reese Davis letter. It does not matter whether the contents of those letters can be questioned as unreliable. That is not for the prosecutor to determine. The prosecutor's only determination is to turn that evidence over to the defense. The defense should have had the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has a constitutional right to possess all exculpatory evidence and then to determine how it should proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact that the prosecution had in its possession letters in which a key suspect, Keegan Klein, purportedly confessed to the crimes and provided details that only the killer might know, and that information should have been provided to the defense. Because the prosecution's failure to produce those letters, and because the prosecution has a history and a pattern of not turning over exculpatory evidence, Richard Allen deserves another trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Reese Davis letters, why he misrepresented his possession of those letters to the defense counsel on February 13th, 2025 email, as well as to explain other examples of failing to turn over exculpatory evidence as recited herein, which shows a pattern of such conduct. The defense seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in a renewed motion for a new trial based upon newly discovered evidence. And also, 2, in order to use the state of Indiana's answers to those questions as a record that can be utilized by the appellate lawyers should this court deny Richard Allen his request for a new trial. Lastly, Allen asks this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. And instead of an affidavit, what we have is, I swear and affirm the statements are true and accurate. I wish in this wherefore he would have said, and he wants a hearing where Reese Davis can be called about the contents of the other letter, where Reese Davis can be called about his communication with any communication with the state, be that law enforcement, be that prosecutors. I just wish, he asked for a couple more things here.
Yeah, no, look, the only thing that I would have liked to have seen, and I wish that we had time to bring Michael on, but we don't, because we're about to bounce in 10 minutes. So I'm sticking to our 5:40 deadline.
You said
Is that
5:45. We could bring Michael on for 15 minutes.
should we bring him on? All right, Michael, if you're still in there, because Andy is a wonderful writer. I truly enjoy the way he writes. Sometimes I wish there was a little more case law, which is why.
There's a couple of sites, but no.
Michael, I just sent the invite. Hop on real quick. There was some, but I'd like to see the case law that articulates and just backs up what Andy's saying, because
you can request a sanction of a new trial
all of it, case law that talks about the requirement for them to turn over.
I think that was in that was in the initial motion.
All right, I'm going to ask you this honestly. Do you think Judge Gull actually reads his motions?
No, of course not. But it just needs to be in there to preserve it, for the.
Look, all right, let's bring Michael on. Hey.
Hey there.
How are you?
Can't complain. First day of shorts. Happy birthday to Allie, a day early. Some people think celebrating a day early is bad luck, but I don't believe in that.
No, we
I've
don't
never
either.
even heard of that.
No, we do. We always wish happy day before your birthday day. So it's we start early and go often. All right. So Michael, what were your thoughts on this particular filing?
I think that I don't think he could ask about Brady because the motion to correct error is done. But I think a motion for discovery sanctions is sort of beyond. It's not a motion to correct error kind of thing. So, I think there's another motion pending. And there's another thing that could be done. It's called the belated motion to correct error. And I think it's post-conviction rule 2-2. So, if you miss the 30 days, but, it really wasn't your fault, you can file a petition to file a belated motion to correct error. Well, of course, they filed a timely motion to correct error, but the rule says you can file a belated motion to correct error if one wasn't timely filed or if it was inadequate. And I think this is a really interesting case to say that, yeah, it was inadequate. And the reason it was inadequate was guess who?
Right. More evidence came to light thanks to the state not producing it. Right.
Yeah. And I've got one Indiana Supreme Court case saying sort of you can do that. It's from '89. So it's old. This isn't something that happens a lot, but,
I mean, you've got to think that if evidence comes to light after you filed your motion to correct errors, and then she hastily denies it when she can see damn well you're trying to get more evidence. Now, I told everyone in the beginning I was going to check the initial pleading to see in the conclusion or the wherefore clause if he asked for leave to amend the motion once he got this evidence, and he did not.
You can't amend.
Okay.
Once the 30 days is gone, you can amend with, if you file it in 15 days and on the 29th day you've got something new, it's before the 30 days, you can amend. But you couldn't even amend. I mean, this isn't based on facts that are in the original motion to correct error under Trial Rule 15C. You could try to amend to get relation back, but it's new facts, and so it's not gonna.
It sounds like,
yeah.
based on what you're saying, there's at least something to lay his hat on to file a belated motion.
Yeah, absolutely. I mean, it's a really unusual thing, but I do habeas work. It's all procedure.
Right. And habeas work, for those of you that don't know, is basically when you've exhausted all your remedies in state court and you're going to, well, you do federal habeas work or you do state habeas work?
Oh, a little of both, but mostly federal habeas.
And you're saying to the federal government, the lower courts, the state courts have just trampled all over the clearly established federal law. It is a very high burden. It takes extensive legal knowledge, legal research to even get your foot in the door. And that's what Michael does. He brings things back from the dead. Essentially, that's what a habeas lawyer is doing, getting you that one last lifeboat.
It's funny you say that, because I've said it. So a lot of the cases that I get come from the state PD's office, and I've told the folks up there that what I do is I dress up the corpses, and occasionally the chief undertaker sends one back saying not dead yet.
Exactly.
So, Michael, in terms of this particular motion, I mean, we all anticipate exactly what will happen, and I'm sure it's going to, like, I won't be surprised if she denies it without hearing tomorrow.
Should he have asked, do you think, Michael, that for the hearing to include Reese Davis coming in and testifying as to what else he sent or said or communications had by and between himself and law enforcement or the prosecutor's office?
Well, I mean, I think in the unlikely event it's set for a hearing, you can count on Reese Davis being subpoenaed and a transport order requested.
Yes, I would imagine.
And the thing that McCleland doesn't answer is one of those letters that he, quote, recovered, mentions a note from Keegan Klein. And where's the damn note?
Right. I wish he would have mentioned that in this motion, that the note that was attached specifically references another document being attached that was not produced.
I mean, I'd want, look, for two reasons. For one reason, it's very hard to give McCleland the benefit of the doubt here. I mean, on one version, so the receptionist that Reese's uncle called said, some number of letters have been passed along to the people investigating the case. It's possible McCleland knew nothing about them.
He's got a duty to ask the law enforcement if they received any other letters before he puts his response together. Would you agree?
Well, he did, and he got them. But what I want to say is the reason it's hard to give him the benefit of any doubt here is the surety response that he gave to Andy Baldwin when Andy Baldwin did the right thing and simply asked him about them first. And McCleland basically told him to go pound sand.
Right, but they only turned over 2. So has he looked? Has he searched? Is it possible to ask for a sort of like they do with like sort of the taint team or a special prosecutor to come in and do a discovery review? See if they can find this other letter. See what else has not been turned over. As part of this sanction request, I was hoping maybe that was something to ask for.
I'd have to go look at the request if I recall correctly, the request to preserve and produce evidence also asked for preservation of all the communications having anything to do with Reese Davis.
Yes, yes, to preserve all records in whatever form and communications, electronic or other, including emails, text messages pertaining to Reese Davis. It does
Yeah.
ask for that.
So, hopefully, yeah, you could get somebody independent in there. You know, I'm a little concerned. I don't like to say people do this, but I'm a little concerned that this. Look, we've got all kinds of missing evidence in this case, and they're claiming it's all inadvertent. And when if there are other letters, I have no hope they still exist.
Right. And I would agree like wholeheartedly with the concept that based on just this filing alone, the court should determine that McCleland has lost any benefit of the doubt.
Well, I was saying on R&M's live today, she could still deny this, but boy, if I were the judge, I'd want to get McCleland in there to do some explaining.
You've got some explaining to do.
So,
And,
Michael, let me ask you. I know that you've been on. I've never watched the channel, but I know that this channel, what is it, Case by Case or Case X Ace, or I don't know.
yeah,
So they have been able to get Reese Davis on the phone. People keep telling me I should check that out. Can you give me
he was on the phone. He was on the phone Friday night, and so conveniently, one of the letters that's missing is there's a later letter when he heard from Keegan Kline. This is what, as the wonderful guy on To the Point says, everything is alleged. That said, Reese says, there was a later letter, and maybe more than one, after Keegan Kline admitted that Rick Allen wasn't involved, and Reese wrote another letter then saying, Rick Allen wasn't involved, and strangely enough, that letter's disappeared.
It's crazy.
Huh. So I mean, were you on the live when he was calling in?
I was.
Were you able to ask him any questions?
I didn't ask him any questions. I said hi. He said hi. I mean, we kind of know each other from earlier days.
Yeah, I'm aware of that. Did you did anybody put his feet to the fire a little bit, or was it, kind of all coddling? Like the things that I'd want to know is like, why is he writing letters to other prosecutors? Because you want to try to.
Do we even know that those are other prosecutors? Or are those who
he hasn't written any other prosecutors?
Okay, so,
I mean,
so what Keegan Kline is writing to the murder sheet was bullshit, is what I'm getting at.
Oh, absolutely.
Okay.
Absolutely. And of course it's going to be bullshit because, he spilled the beans to Reese, and now he's got to walk that back as fast as he bloody well can.
And so does it, I mean, do you find it a little bit odd that in McCleland's filings that, I mean, do you think that he had communications with that particular podcast in order to find out if they were communicating with him in order to ask for those chats? You know what I'm saying? I'm trying to figure out where McCleland gets it in his head. Hey, you know what? I should reach out and try to get the chats from Reese Davis with all the other people, just to case, you think he was tipped in on that, hey, you should get the ones from us because we're talking about a lot of that with him, and he chats back to us. I mean, you think he was tipped on that at all?
I don't know whether he was or not. I mean, it's something I'd do with it's something I'd do if I were the prosecutor. I'd want to see at least, the recent communications from Keegan Kline. And by the way, I think Allie made the point yesterday or the day before that, Andy couldn't just call up the DOC and say, give me all this stuff.
Not a chance. Not a chance.
And I mean, he'd have to file a third-party subpoena, probably. Got to wait 14 days on those, unless you get
Give
the judge
DOC a chance to object if they wanted to.
Yeah, I mean, it could all be spun out, and everything's denied, and the notice of appeal has to be filed, and that's coming in. Today's the 4th. That's coming in 2 weeks. The 20th is the deadline.
So based on your looking through the tea leaves and what's been filed thus far, you believe it's possible we should stay on lookout for another motion to correct errors, a belated motion to correct errors.
I don't know. I'm not even the pilot monitoring. I'm kind of
reading the tea leaves.
Reading the tea leaves, I have no idea. These people are very busy. I don't know if they want to, be filing any more stuff. And
I mean, apparently, Andy just wrote up this 24-pager. Yeah, I kind of, and Michael, unfortunately, we got to go because we got a bunch of our kids coming, and our grandbaby are going to be here in 15 minutes. But I just want to end on this, that, for those of you, typically, when you have a case that, you go to trial, it's hard fought, your client gets convicted, typically you're going to allow it to shift over to the appellate attorneys. The fact that Baldwin continues to try to get this in front of Gull and have her look at things and have the state, and I mean, it should speak volumes about whether or not Andy believes that his client is factually innocent of this case, because most lawyers, whether it's a good thing or a bad thing or an indifferent thing, just kind of step back and they let the appellate process take its, after, but and I'm talking about specifically after whatever the post-conviction motions that you have to file in our state. Right. But this is beyond that. He's continuing to fight. He's continuing to try to get things in front of Judge Gull. He's continuing to try to get her to make him answer, him being McCleland, for something, to get something on the record, some kind of explanation as to how these things that we've just read about all occurred under her watch without her requiring any kind of explanation as to how any of it has occurred. I mean, to me, I've never seen anything like it, man. What I see all the time is the judge will ask the question, okay, and the prosecutor will say blah 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 blah, and they'll say, right, okay, that's sufficient.
At least they try. At least they pretend to try.
Right. At least
sometimes
she doesn't even pretend to try. And it's disheartening and it's scary. It's both things.
Well, thanks for joining.
I only wanted to add that, in addition to getting it all in front of Gull, I mean, it's, the appellate lawyers, Stacey and Mark, don't know anything.
For sure.
Don't know anything. And this is kind of educating them. And it's also
developing
information for the Court of Appeals.
Right. 100%.
Thanks, Mike.
There is actually a claim, a discovery claim here. It's an abuse of discretion standard, but boy, they could reverse on that.
100%.
That's why making the record is so important.
Critical.
All of this stuff, even though the judge might not be doing, oh, you're wasting your breath. It's not. It's making a record. Well, thanks a lot, Michael, for
We love you,
joining us.
man. We'll have you on when we can have a longer talk, but we appreciate you jumping in and giving us your insight always.
Thanks for the opportunity.
Thank
Always.
you.
All right. Bye.
All right, babe. I need you to thank all the people. That need to
Okay.
be thanked. And you promised a song. I don't care.
We didn't make the goal.
I
We
don't
didn't-
care.
we
Do it
didn't make the
anyway.
goal. You don't make the goal. You don't get the. You
Oh,
don't get the
come
prize.
on. Just give it to them.
I'm not doing it. Dr. Vonda, 5 gifted memberships. Thank you, thank you, thank you a million times over. Jessica Gilman, $5. Happy birthday, Allie. I'm grateful for all the shared wisdom. And we're grateful that you're here with us. Cool lady, member for 10 months. Happy birthday, Allie. Lisa Shelton, what up, girl? Happy birthday. Thank you, thank you, thank you for your generosity. Sherry Sykes, happy birthday, Allie. Glad all the coverage you both do for Richard Allen. Thank you. Thank you for hanging with us. Thank you for being willing to, a lot of people aren't willing to listen. So you should thank yourself for being a person with an open mind and caring about your country and what's going in its courts. Thank you for your generosity as well. Thomas, Mel, thank you. Happy birthday. $5. Solid. Skeptic Curiosity, $10. Happy birthday, Allie. Thank you, Skeptic. We appreciate you. Melissa Dowling, thank you guys. Thank you, Melissa. We appreciate it.
Yes, we do.
CW, $2. Poor, I'm poor. Sorry, never apologize. We appreciate anything that you guys scrape up and send to us. It's always massively appreciated. So thank you very much for that.
As
Happy
are
birthday.
all the memberships. Definitely appreciate that.
The memberships are huge. Happy birthday, fellow Pisces Alley. Nice.
Nice.
Uh,
Whenever your birthday is, happy birthday.
Musarad Siddiqui, longtime listener of the podcast and YouTube. Happy Ramadan and thank you. Thank you, Musquat. We appreciate that. And thank you for generosity. 10 pounds, British. Love it. Mary Holt, $10 holla. Happy birthday, Allie. I love that Bob is grifting for your birthday. You enjoy your birthday. Love grifting. It's the best. I mean, if people are going to call me a grifter, I might as well actually grift. Thank you. Were you say something?
Yeah, I mean, they our mods starred Free Radicals question, and I just think
I started.
Okay. Why didn't Baldwin call Davis to the stand after their earlier meeting? It's a good question, but I think it should be formed. Why didn't Baldwin call Davis to be deposed? Because he couldn't call him to the stand because the judge had ruled out all third party stuff, and he didn't really give him enough information. But there was something there. There's a missing video, maybe a deposition would have been ordered, but he couldn't call him to the stand. All right.
Dr. Vonda. Thank you. TJ Bits, $2 holla. Appreciate you. Thank you. And Miss.
4 months. Thank you.
4 months. We love that. Thank you. Welcome to the family. EKG, $5. Please restart Avery Podcast. We were just talking about it today. It's coming.
It's definitely coming. Bob's just got to finish Tunnel Vision, the Dr. Anthony Garcia story, and we're gonna do it.
DB, I love hearing 2 outstanding attorneys talking about the intricacies of the law like this. And Bob's here too.
Ha ha ha.
Love you, DB. Don't be hating. Happy birthday, Allie. Bob, just sing now.
You're gonna sing.
Full-throated motion. Love that. I love that so much. It's such a great moniker. $10 holla. Enabling the grift. Happy birthday, Allie. Sing the song. Happy birthday to you. Happy birthday to you. Happy birthday. Happy birthday to you. I love you, baby.
I love you too.
Happy birthday.
And we love all of you.
We love you guys so much. Thank you for hanging with us. We will see you tomorrow, bright and early for Karen Reed. Actually, 10 a.m. Central Standard Time. Keep your eye out. Please, on the way out, remember to pound that like, smash that like, hit that like, share, subscribe. If you're on replay, please leave a comment. It helps grow the show. And it's all free. You can do it for free. And we love you. Because without you, I'm an old man.
Just talking to his wife.